Hello, everyone, and welcome to another day on Pul342 Criminal Law 2 and on Topic 5. Today, we shall continue our discussion on offenses against the administration of justice. The other time we commenced and we mentioned some offenses like contempt, perjury, and all of that. And today we shall go on to also talk about other offenses. This time we shall be focusing on corruption, and we shall be looking at bribery. We shall also be looking at extortion. Who are those responsible when these offenses are committed? The giver of the bribe and the taker, who is responsible, are both responsible. We shall look at all of this and their provisions that are being provided for them. We shall also be looking at some of the laws that gives us an insight when some of these offenses are committed and the way the law looks at it and punishment that are being prescribed for such offenses. Like we shall be looking at the EFCC Act, we shall be looking at the ICPC Act, the Money Laundering Act, and also we shall be looking at some other commission like the Public Complaint Commission. We shall also be looking at such act or commission to see how or in what way they can affect such when such offenses are being committed. I'm Dr. Alera Akujobi, your facilitator for this class. So once again, get ready with your sources, with your penal codes, your criminal codes, the Constitution, and of course any other book or whatever that will aid you in this during this facilitation. So good afternoon. Thank you. Good day, everyone. Now, what are those things we shall be looking at for? We are looking at offenses against the administration of justice. And in this, we shall be looking briefly at perjury and also the issue of contempt. And before we go into corruption, as the case may be. So what do we mean by perjury? Normally, just briefly defined, perjury is giving false testimony on oath. When somebody is before a properly constituted body and he is told to give testimony on oath, and he normally does so, giving such testimony, knowing them to be false, knowing them to be wrong, and he also knows within himself that such things are, or whatever he is saying is wrong. That, of course, is a false test, is perjury. So accordingly, perjury must be committed if false statement or testimony is made in a judicial proceeding or under oath before anybody that is authorized to administer an oath to witnesses who appear before it. And this is from section 117 to section 118 of the Criminal Code and also section 156 of the Penal Code. Note also that under the law, the offender cannot be arrested without warrant. So what are those necessary things that must constitute perjury? One is that the testimony must be false. Two, that the testimony must be in the course of a judicial proceedings. Three, that the testimony must be relevant and material. In other words, you cannot be talking of a matter of theft and you are bringing in issues of rape and things like that are not relevant to the facts in issue. So the matter must be relevant to the facts in issue. Also, the accused must know that whatever is saying or the testimony is given, that it states attacking an Attorney General of the Federation. It's a very interesting case. Get hold of it and try and read it so that you can understand all about the law of contempt. There are many other questions on contempt too that you might come across, other cases of contempt that you might come across. But the important thing is to protect the integrity of the court, to protect the court from anarchy and chaos, particularly when matters are going on. That is what gives the court such inherent powers, to protect its very own. So, having said that, we shall go on to the other topic that is under official corruption and judicial corruption. So official corruption in the sense that, what do we mean by corruption generally? Before we talk of official or judicial. Generally, we're talking about corruption, we're talking about anything that undermines one's integrity. Anything that is looked upon as obnoxious and degrading, e.g., nepotism, tribalism, sexual favors. These are all examples of corruption. Now, however, for our purpose, we're only interested in official corruption and judicial corruption because as it affects those in the public sphere, those that work in public office, I mean, for the in public offices. It's not as if corruption are not in it's not in every other sector, but for this purpose of our facilitation, we shall be looking at official corruption, which is seen as an offense that aims at the conduct of public officials who take advantage of their position or situation to procure some benefits, private gain for themselves or some other persons. And under this, we have things like bribery and extortion, uh, bribery, extortion, and corruption generally. Okay, so what are those laws on corruption? For we have the Constitution, we have the Code of Conduct Bureau and Tribunal Act, we have the Independent and Corrupt Practices Commission, the ICPC, Economic and Financial Crime Act, EFCC, Money Laundering Act, Public Procurement Act, and so many as Public Complaint Act, and so many more. So let's briefly look at some aspects of corruption, like bribery. Talking about bribery, what do we have in mind? Bribery is the offering, giving, and of course, it is also the receiving of some value for the purpose, receiving of something, receiving of property, receiving of gain, you know, for the purpose of influencing the action of influencing your action in your duty, in the discharge of your work. Is when you take, when you receive, when you solicit anything, either in property or whatever, anything that is of gain to you, so that you anything that is of gain to you before you can discharge your work or your public duties. So both the giving and the taking, whoever gives and whoever takes, they are all involved in the act of bribery. The act of bribery concerns only official acts, and no offense is committed when person's actions outside the official sphere are influenced by the bribe. For instance, if you take in your place of work, maybe you are there at the you are a lecturer, and you are if the money you are taking for this particular person, for instance, does not have anything to do with your lecturing business. Maybe it's for some other act or for some other thing that the person wants from it outside your duty as a lecturer. Of course, that will not be deemed to be official corruption for that particular purpose. So sections that are relevant here are section 98, 98A, and 98B of the criminal code, that talks about bribery. Importantly, the element that should look out for is the guilty act, which manifests when the public officer asks or receives. That act of receiving, that act of giving, that act of soliciting is deemed as guilty, is deemed as dishonest. So that is the mens rea, the guilty act of it. Now, of course, the receiving too must also be done with an intent too, for the purpose of influencing your mind, your mindset, and all of that. And of course, the benefit and favor, if there should be offered, received of any kind. So, of course, the giving and the receiving must pass. And when you are giving, it must be for a benefit, for a favor. You taking to must also be for a benefit or for a favor. So, who are public officers? Public officers are those employed in public service, and they normally include civil servant, civil servants, members of the public, religious officers, justice of peace, local government workers, and this can be found in section 1, subsection 1 of the criminal code. Judicial officers are also included, okay, because there are also people before whom judicial proceedings are held, in which evidence are taken. E.g., members of the court, members of the jury, members of the tribunal. So, Section 98 also says judicial officer cannot be arrested without warrant for any of the offenses of bribery and extortion. So, that should also be noted. So again, when we are talking about a complaint or information against a judicial officer, it must be one that has been approved or signed by the Attorney General of the state or federation, as the case may be. So, briefly, let's look at what extortion is. Now, unlike bribery, extortion is also another form. Like bribery, Extortion is another form of collecting favors, benefits, but this time it is under the color of office. However, where it is one of the major differences is that why bribery is can be done voluntarily between both parties. I want to give you, I also want to receive. Under extortion is normally done using the threat of future harm or violence. It's like a policeman stopping you on the road and says, if you don't give me money, you can't move, or I'll shoot you. So under the presence of threat of harm or violence. So extortion of public office, according to Section 98 of the Criminal Code, is by any person who has been employed in public service who takes or accepts from any other person for the performance of his duty. You know, any reward beyond his proper pay or emolument or any promise is guilty of the offense of extortion and is a felony. It's also punishable with 3 years imprisonment. So basically, what are the differences? Differences between extortion and bribery is that in the offense of extortion, the public officer is using his office as a lever to extract the money, and the payer of the money can usually, if not always, be regarded as the victim. Whereas in bribery, on the other hand, the payer will usually be a party and an accomplice, a willing party and an accomplice. I think that's basically one of the difference. Why one, the victim is, will I call him the victim now? Is a willing party. The other one, the victim is not a willing party and is under threat or duress. So again, one extortion will injure the individual who is made to yield to it. For instance, the victim, it injures the victim. Bribery destroys the society. Bribery destroys the common purpose of the common will of the society. So it's not just the giver of the bribe, not the receiver, but it's an offense against the community. Because when you take such offenses or such bribe to do or not to do what you are supposed to do, the effect of it bounces back to the society. So see the case of Baobako and the police. Baobako and the police is an interesting case that you read and you understand what you read. So briefly, we shall look at some of the laws that make up the offense of corruption. What are those laws that we're talking about? The ICPC. The ICPC we realize is also that is ICPC fully is known as Independent Corrupt Practices and Other Related Offences Commission. It has powers to receive all cases of alleged corrupt practices under the Act. It has power to receive all cases, investigate cases, and prosecute them. So it has power to receive, investigate, and prosecute. So to that section, many sections of it, 45, 46, up to 52 are all relevant. Okay, for that of ICC. Again, like I said, it covers acts of corruption that are committed both by the public and also by the non-public officials. So it covers acts of corruption that are committed by both public and non-public officials. It has powers to investigate, powers to prosecute, and also power to receive all cases of corruption. That is the ICPC. Okay, so I would encourage you to read the act, you know, and of course understand what the kind of offenses it can look into, what it refers to as gratification, and things like that. Okay, it also makes reference to offenses of accusation, fraudulent accusation of property. So these are all under the ICPC. Deliberate frustration of investigation by the commission. What is the punishment for that is 7 years. When you know of facts of a particular crime or you are frustrating the investigation of that particular crime, you are eligible for punishment for 7 years of the criminal code rather than bribery under section of the criminal code. Now, Section 18 of the ICPC makes it an offense for any person to give bribe or to a public officer or for a public officer to solicit counsel or accept gratification in respect of an act or omission which includes voting or abstaining from voting at any meeting of public body in favor of or against any measure. Receiving bribe to vote at meetings wider than that covered under the criminal code. The punishment is wider under the ICPC than under the criminal code. So those are some of the differences. Again, what is the duty imposed by the ICPC on a public officer to whom the offense, their bribe has been given? The duty primarily is to report such offenses or such acts to the appropriate body. Now, briefly under the EFCC Act, this is again another corruption body that its main function is also to arrest or to investigate and conduct arrest of any forms of fraud or conduct leading to money laundering, embezzlement, bribery, tax evasion, foreign exchange malpractices, looting, and any form of corrupt practices. So the powers are spelled in Section 6 of the criminal of the EFCC Act, Section 6. Section 16 refers to false information given by public officer, and punishment is normally 2 years or more to 3 years. Under forfeiture of assets, um, where um, um, where where one is found with an asset that does not belong to it and proper investigation is done under section 20, 21, and 22 and 23, such assets are normally forfeited to the federal government. Again, under the Money Laundering Act, it's another act or another law, Money Laundering Act 2011, that is also there for the protection um, of, uh, of, of the society by making persons that are found wanting, to also wanting of proceeds of crime, to also relinquish such proceeds. So it prohibits laundering of the proceeds of crime or an illegal act among others. So it flows. It's normally money laundering flows from illegal acts such as arms sales, smuggling, drug trafficking, advanced field fraud, embezzlement, bribery, computer fraud, crimes, all kinds of white collar crime. Normally, it's an umbrella. Many people use it as to generate. They use all these forms of crimes to come to siphon ill-gotten wealth and and siphon it to different kinds of accounts. So basically, Section 14 provides for prohibits, disguising the illicit origin of sources of property. Again, it also makes limitation of 500. Normally, an individual should not be able to, in most of the banks, an individual should not be able to deposit more than 500,000, while thousand naira, while corporate body normally is 2 million naira. Again, at time when you find yourself traveling, you are normally asked not to carry over $10,000 outside the country. Where you normally have such money beyond that, you normally have to declare what you have in your hand before you can travel. So Section 15.1 provides for various offences concerning acts prohibited under the Money Laundering Act. So you can go back and read some of these offences. Now, lastly, we shall look at some questions we have here. Before then, when you are most times you are caught with money, depending on the type of offense you've been caught with, that will determine the kind of punishment you also will serve. So normally it is not just enough to confiscate whatever you've gotten, but also you could serve some time in jail to act as further deterrent for being in possession of such monies or such illicit gains. So the question here is to discuss the scope of definition of economic and financial crimes under the EFCC Act make the fight of those crimes more effective than under the Criminal or Penal Code? That is one. Two, why is the prohibition of money laundering essential to the fighting of corruption and other crimes? So you are expected to look at some of these questions, discuss them, and make an attempt at answering them. Where there are questions, please get back to my mail and let us discuss some of the questions or confusing areas that you are not very clear with. Again, your course materials are there for you to also go through. Please do that, and as you read along with your some of the sources of some of your textbooks, like the your codes, your constitution, and even some of the law reports that will throw more explanations on some of these offenses we are discussing. So I want to thank you for your time once again. We'll meet again next week. Thank you.